This trial, of course, the culmination of many rounds of defeats for defendant Trump.
Donald Trump once again in a courtroom with the fate of his business empire now on trial.
I decline to answer the question.
The 2019 Statement of Financial Condition contained false and misleading valuations and statements. Is that correct?
Same answer.
We haven't done a damn thing wrong, and they dragged Don and I into it as collateral damage. You know why?
I should have worn makeup.
But I will not be bullied. I will not be harassed. This case will go on.
She was right. The case went on, and while there were many different tactics to try to obfuscate or delay, as our guest Bill Kristol just mentioned, she would win those rounds. As for today's ruling, now years in the making, it was quite exhaustive. The judge found, I want to show you this so you can see with your own eyes some of the key parts, that in order to borrow more.
Breaking news, the verdict is in. Judge Arthur Engoron has issued his final judgment in the New York civil fraud trial against Donald Trump, and the number is $464 million, $354 million in disgorgement. The financial benefit Trump obtained through a decade of systematically inflated financial statements, plus approximately $100 million in prejudgment interest, plus a 3-year ban on Trump operating a real estate business in New York, plus similar prohibitions on his sons Eric and Don Jr. And this judgment does not arrive alone. Add the $83.3 million Eugene Carroll defamation verdict from just weeks ago, add over $50 million in legal fees across multiple proceedings. The total legal obligations Donald Trump has accumulated, largely, if not entirely by his own making, now exceed $500 million and continue to grow. Judge Engoron's 92-page ruling contains a phrase that may be the most damaging 2 words in the entire legal saga: denied reality. That is how the judge described the testimony of Trump and his witnesses when confronted with the documented evidence of fraud. Not disputed, not challenged. Denied reality. Tonight, we break down exactly what the judgment found, how it was calculated, why the denied reality finding matters, and what $500 million in legal obligations means for the man who built his entire identity on being a financial genius. The $464 million judgment did not appear from nowhere. It is the culmination of a legal process that began years before the trial, and understanding what the number actually measures is essential to understanding why it is what it is. The fraud finding itself was established before the trial even began. In September 2023, Judge Engoron issued a summary judgment, a pre-trial ruling based on the documentary evidence alone, finding that Trump had committed fraud. What the trial was determining was not whether fraud occurred, it was how much the fraud was worth. How much did Trump benefit? For how long? What was the appropriate remedy? The base penalty, $354.8 million in disgorgement, represents Engoron's calculation of the financial benefit Trump obtained through approximately a decade of submitting inflated financial statements to banks and insurance companies. The theory is unjust enrichment. Trump obtained better loan terms, lower interest rates, and more favorable insurance premiums by presenting financial statements that overstated his asset values. He repaid the loans, but the lower rates he paid on those loans, rates he would not have obtained without the fraudulent valuations, represent profit from fraud. Disgorgement strips that profit away. Give back what you gained through the lie. Add approximately $100 million in prejudgment interest, the 9% annual rate that accrues automatically on New York civil judgments from the day they are entered, and the total for Trump personally reaches $464 million. With the penalties against his sons added, the full judgment against all defendants exceeds that figure by a significant margin. The financial fraud was not a single transaction. It was systematic multi-year overstatement across the entire Trump Organization portfolio. The 2014 Statement of Financial Condition valued Trump's assets at approximately $5.6 billion. Engoron found the accurate valuation was approximately $2.2 billion less than that. Across a decade of financial statements, the overstatements were consistent, documented, and applied to virtually every major asset in the portfolio. Of all the findings in Judge Engoron's 92-page ruling, the 2 words that carry the most weight and that will follow this case through every subsequent appellate proceeding are denied reality. Courts evaluate witness credibility in every trial. Judges and juries constantly weigh competing accounts, conflicting documents, and disputed interpretations. That is the normal work of a courtroom. When a judge concludes that a party's witnesses denied reality, they are making a credibility finding that goes beyond ordinary dispute. They are saying the documentary evidence is clear. The witnesses' contradictions of that evidence are not credible, and the court does not believe them. Trump himself took the stand during the trial, an unusual choice for a civil defendant, and testified directly about the financial statements. He said the valuations were accurate. He said the numbers were conservative. He said the banks were sophisticated and knew how to assess property values. He said his assets were worth more than his statement showed. He was not believed. The same judge who watched Trump invoke his Fifth Amendment right against self-incrimination approximately 440 times during depositions, refusing to answer questions about his own business on the grounds that truthful answers might incriminate him, then watched Trump take the stand at trial and testify expansively in contradiction of documented evidence. The contrast was not lost on Engoron. The denied reality finding reflects a judicial assessment of a defendant who refused to answer questions under oath and then contradicted documents under oath. In a civil case, unlike a criminal proceeding, a court can draw adverse inferences from a party's invocation of the Fifth Amendment. Engoron did. He noted the extensive Fifth Amendment use and concluded that the refusals were consistent with the overall fraud finding. 440 invocations of the right to silence in a case about financial statements became part of the evidentiary record rather than a shield against it. The denied reality phrase is now in the legal record permanently. It will appear in appellate filings. It will be cited in any future case that references this judgment. And it is the court's definitive assessment of what happened when Trump's defense strategy, deny the numbers, dispute the methodology, attack the judge, met a judge who had spent months reviewing the actual documents. The abstract figure of $354 million in disgorgement only becomes comprehensible when examined through the specific properties whose inflated valuations produced it. Engoron's ruling documents the fraud through concrete examples, specific properties, specific numbers, specific gaps between what the financial statements claimed and what independent analysis showed. Mar-a-Lago is the most extreme example. Trump's Palm Beach estate, a property subject to a deed restriction agreed to by Trump himself in exchange for historical preservation recognition that prevents residential conversion or subdivision, was valued on Trump's financial statements at various points between $426 million and $612 million. Independent appraisers valued it at between $18 million and $27 million. The gap is not a matter of methodology or judgment. It is a factor of 15 to 25 times. Engoron found that valuing Mar-a-Lago as if the deed restriction did not exist, as if it could be sold as a private residential estate without legal limitation, was fraud. The restriction is documented. Trump agreed to it. Using valuations that ignored it was not aggressive estimation. It was stating as fact something that the legal record directly contradicted. Trump Tower presents a different but equally direct example. Trump's personal apartment was listed in financial statements as 30,000 square feet. Multiple independent measurements showed it was approximately 10,000 square feet, roughly 1/3 of the stated size. The overstatement of floor area produced a valuation approximately 3 times what an accurate square footage calculation would have generated. When Forbes magazine confronted Trump's team about the discrepancy, the records were not corrected. The overstatement appeared on financial statements year after year. Seven Springs, the 212-acre Westchester estate where former controller Jeff McConey testified that Eric Trump told him to include the value of 7 homes that had never been built, was valued as if a residential subdivision existed that existed only on paper. The estate Trump purchased for $7.5 million was valued on financial statements at numbers that reflected a completed development that had never been approved, never been built, and faced substantial regulatory and local opposition. These are not marginal examples at the edges of the portfolio. They are the core assets of the Trump Organization's financial presentation to banks and insurers, and every one of them was dramatically, systematically overstated. Throughout the trial, Trump's legal team advanced one argument above all others as their central defense. Nobody lost money. The banks got repaid. The insurance companies never paid losses. There are no victims. And without victims, there is no legitimate basis for a fraud penalty of any amount, let alone $354 million. The argument sounds compelling on the surface. If everyone got their money back, what exactly is the harm? Judge Engoron addressed this directly and definitively. New York's civil fraud statute, section 63-12 of the executive law, does not require victim loss. The equitable remedy of disgorgement, taking back the unjust profits from fraud, does not depend on a victim coming to court and demonstrating financial injury. The law recognizes that sophisticated counterparties can be defrauded without suffering direct financial losses. When you lie to get a better deal, lower interest rates, more favorable loan terms, cheaper insurance premiums, you have to give back the benefit of the lie regardless of whether the other party ever discovered the lie or lost money because of it. The absence of a victim who lost money is not a defense under Section 63-12. Engoron said so explicitly. The appellate division upheld the fraud finding in August 2025. The no victims argument failed at every level of the judicial system. There is also a broader harm that the no victims framing obscures. When Trump obtained lower interest rates by overstating his assets, honest borrowers who presented accurate financial statements were paying higher rates on the same market. The fraud did not just benefit Trump, it tilted the competitive landscape against every business and individual who played by the rules. That systemic harm does not require an individual victim with a documented dollar loss to be real and legally cognizable. The February 16, 2024 judgment is the end of a legal journey that began not with a lawsuit, but with a campaign promise, and tracing that journey illuminates what the ruling actually represents as a matter of institutional accountability. Letitia James ran for New York Attorney General in 2018 on a specific platform that included investigating Donald Trump's business practices. She made the promise publicly during the campaign and kept it. The investigation began in 2019, drawing on and building upon congressional investigations and the Southern District of New York's civil inquiries into the Trump Organization. The formal impetus that led directly to the lawsuit came from Michael Cohen's congressional testimony. Trump's former personal attorney describing specific instances of Trump inflating asset values for financial advantage. James filed the civil complaint in September 2022, initially seeking $250 million. Engoron's summary judgment in September 2023 established fraud before the trial started. The trial produced testimony from McConey, from former CFO Alan Weisselberg, and from Trump himself. And the February 24 judgment is the culmination of 6 years, from campaign promise to courtroom ruling. Trump's legal strategy throughout was layered obstruction. Delay at every stage, challenge every ruling, appeal every loss, demand recusal, attack the judge's impartiality, challenge the Attorney General's authority to bring the case, dispute jurisdiction, argue the statute of limitations. Every available tactic was deployed. Every single one failed. Motions to dismiss were denied. Recusal demands were denied. Appeals of the summary judgment were denied. Jurisdictional challenges were denied. The no victims argument was denied. Trump took the stand and was found to have denied reality. And James, who said from the beginning that the case would go on, was right. It went on. And it ended here. $464 million, a 3-year business bar, and the most comprehensive judicial finding of fraud against a major American business in recent memory. The anchor's summary, over $500 million in legal obligations and counting, is not an approximation or a rhetorical flourish. It is a conservative description of the documented financial exposure Donald Trump had accumulated as of February 2024. The Engoron judgment, $464 million for Trump specifically, with additional penalties for his sons. The Carroll defamation verdict from January 26, 2024, just 3 weeks before the fraud judgment, $83.3 million. Prior legal fees across multiple proceedings, the hush money case in New York, the Georgia election interference case, the federal January 6th case, civil discovery and motions practice across all fronts, running into the tens of millions. The total, conservatively calculated, approaches or exceeds $650 million, depending on how legal fees are counted. Every component of that total is the direct result of specific decisions Trump made over specific years. He submitted the financial statements. He made the defamatory statements about Carroll. He classified the hush money payments as legal expenses. The legal exposure did not happen to him. He created it through choices that courts have now documented in extensive detail. The business bar, 3 years during which Trump cannot operate a real estate business in New York, represents the most operationally significant consequence beyond the dollar amount. For a man whose business identity, personal brand, and claimed wealth are inseparably tied to New York real estate, Trump Tower, 40 Wall Street, Trump Park, the portfolio of Manhattan properties that have defined the Trump name for 4 decades being barred from operating that business is an existential consequence that no monetary penalty fully captures. And it is worth noting where this judgment stands in the broader legal chronology. The appellate division in August 2025 vacated the $354 million penalty on Eighth Amendment excessive fines grounds while explicitly upholding the fraud finding. Every judge who reviewed the case, including the ones who reduced the penalty, acknowledged that the trial record showed fraudulent conduct. The debate about the amount continues. The finding of fraud does not. The denied reality finding stands. The fraud finding stands. The documents, the testimony, the 92-page record of a decade of inflated financial statements are permanent. Whatever courts ultimately decide about the precise dollar amount, what Engoron found and what every reviewing court has confirmed is that the financial statements were fraudulent, the witnesses were not credible, and the man who built his public identity on being a financial genius submitted numbers to banks and insurers that his own former employees testified were wrong because they were directed to make them wrong. She was right. The case went on, and it ended here. Here is today's question. Judge Engoron found that Trump and his witnesses denied reality when confronted with documented evidence of fraud and issued a $464 million judgment. The appellate division later vacated the penalty amount while upholding the fraud finding. Over $500 million in total legal obligations. Was justice served? And what does it mean that the fraud finding survived every challenge even as the penalty amount was reduced? Drop your answer in the comments. This community consistently brings the most thoughtful legal analysis anywhere on this platform. The best responses get featured in our next video. If this breakdown gave you the full picture of one of the most consequential legal judgments in American business history, hit that like button right now, 2 seconds. That is all it takes. Subscribe if you are not already here. We cover the legal stories that matter with the depth and precision they deserve. Turn on notifications. The appellate process in this case is still unfolding. You do not want to miss the next chapter. Share this video, send it to someone following this case who deserves the complete picture. This is the breakdown they need. Stay sharp, stay informed,